In some states, they say an allowance should be given towards self-represented people. We don't seem to have that in Oregon. So, but I don't think it's fair to be held to a stricter standard. They are allowed wiggle room on who in the world the plaintiffs are and how many claims there are. All this is befuddling to me, and I have to invest. There were 1.4 claims, 2 plaintiffs, him and his wife. All this is like, man, I didn't go to law school. I don't know what the significance of this is. But apparently all that was brushed aside under ORPC 12. I don't know what other reason. I don't know if that's the reason the court chose for that. If you wanted to, I think, be fair, you could have looked at our very first motion to dismiss. They did not respond to that in a timely fashion. If you would have granted that, they would have had to challenge it. And maybe they would realize and say, we don't really have standing to sue for trespass. But you didn't. You know, I submitted my motion to dismiss. And then I had to submit an order for that motion and confer on that. And even though they didn't oppose my original motion to dismiss, they were allowed to oppose my order to dismiss. And all of a sudden, they're not responding. I filed it like on the 31st of December, and they didn't respond to like the 21st. And it was more than 14 plus 3 plus weekends and holidays. And what bad outcome would have come if you would have said, I'm sorry, plaintiff, you didn't oppose. We're going to put it through. I mean, they would have had opportunity to complain about that. And maybe they wouldn't have. Maybe just like my fee filings, they didn't respond for a month and a half. Okay, and somewhere in this case law, it says the rules create an expectancy. I read the rules. You expect me to learn the rules and use the rules, and then the rules are all relevant. The rules, ORCP 68 says, these are the time frames. And, you know, it creates an expectancy when you read the rules and you try to understand them. And basically, the message I'm getting is, why bother reading the rules if they can just be a sidestep? Okay, so I would offer that to the appellate court as evidence of judicial bias. You have raised timeliness of documents against us, but you have not raised timeliness of documents against them that I know of. And furthermore, on the topic of judicial bias, just under a year ago, on the 18th of June, we were here with Rosa. She was over 10 minutes late. And did you launch into the hearing and say, it's time for court? We'll give the opposing party 5 minutes. You gave her as much time as it took to get here. I don't know how long. What if she was a half hour late? Would you have given her a half hour? I don't know. The next time, and then she files a motion for telephonic appearance. And then she said the order. She said that in her telephonic appearance motion, she had an order right with it that said that she conferred or gave us the order. And then so we're expecting, she's going to have to come back. And so we wait in the hallway because we didn't want our children in here getting restless. And you started that hearing. I said, can I please get my family in here? They're just out in the hallway. I don't know that you gave me 30 seconds to get situated before you launch into that hearing. I don't know if I have my paper for judicial bias. Do you remember what else? Okay, in regard to judicial bias, somewhere in case law it says there shouldn't even be the appearance of bias, let alone an actual act of bias. Judges should try to refrain from even an appearance of bias. And that, I believe, validly includes aligning oneself with a party, advocating, assuming the role of counsel on behalf of a party. We, in good faith, I labored to file my ORCP. You indicated at one hearing, attorney fees are going to be ORP 68. I went home and I really labored to comply with that. I filed my documents. They didn't respond, and then you intervened and found fault. You found email fault. Why couldn't you just sit there and say, he's got himself and his wife, they're smart enough, they can oppose if they want. I don't know why you feel it was necessary to join in the attack, step into the role of counsel against us. You didn't do that all along on our behalf, that I know of. So there's that issue. And Mr. Tissot said at one point the court indicated we wouldn't get attorney fees. Well, I listened to a lot of these hearings recently. I don't see where you ever said that. Can you please remind me of where you indicated to anybody that they might not get attorney fees for claim 2 and 3?
My recollection is that was when we were having a hearing in a large courtroom.
That's what I thought. That's what I said, that you listened to it.
Well, that one was on video, and I wanted to listen to it. So, is it in your power to compel a legitimate reason for why they voluntarily dismissed? According to Foster and the M party, I really thought that this Foster versus Matt TISSOT explained a lot of the duty of the court, especially when finding. Now, ORCP 62 talks about findings of fact. I have tried to go to the moon and back to appeal to the court to make findings of fact, according to ORCP 62. Whenever any party appearing in a civil action tried by the court so demands prior to the commencement of the trial, the court shall make special findings of fact. If you read Foster and Matt TISSOT, it's very thorough about there needs to be some substance to this finding of fact so that, if needed, an appellate court can make a meaningful review. In your findings of fact, this is my opportunity to talk about findings of fact.
It's your opportunity to make any argument you want with regard to what you filed.
I might need an intermission of water. Okay, first off, we believe the court frustrated our discovery efforts. We came on the lease, we filed three motions to compel. We got a document that was missing a page. And I said all along, from the beginning, I believe it's best for me to inspect and copy original documents. Rosa at one time was supposed to have it in Portland. I said, Rosa, what documents do you have? Well, I'm not required to tell you which documents I have. I'm only required to tell you when you can inspect them. And then in this upstairs hearing, Mr. Tissot says, we don't have an original of the lease. So you back up, and you compel me to go to Portland if I want to see the original lease. And then Mr. Tissot says, a month or two later, there is no original of the document that has a page missing. So, many motions were made. If we could have somehow, if the bleeding over possession could have been stopped early on, a lot of discovery. For example, if you granted my first motion to dismiss and let him challenge it so much in my discovery, I made that motion at the end of 2018. I shared with opposing counsel necessity of possession, and I have Tamara's response, and she says, in effect, I don't know if it's rented, the property is being rented, and furthermore, it doesn't matter. So I don't want to get distracted from findings of fact, but I don't know if the court or the opposing counsel is able to understand the concept of possession. Where is it? Camera McLeod, 12/7/2018. I'm not sure how to respond. Buyer's standing is 100% clear because he is the property owner. It is irrelevant whether he has rented the property to someone or not, which I don't know. She's prosecuting a lawsuit for trespass, and she doesn't know the relevancy of possession, and she doesn't know who is in possession. Here is my trustee love towards willing processor from the 1970s. Courtesy of a random visit to our local St. Vincent de Paul, fall of 2018. Page 69, trespass the land. An owner who is out of possession cannot maintain trespass. Thus, a landlord cannot sue for a mere trespass the land and occupation of his tenant. Would you like to read it?
I don't need to.
Okay. I reviewed our hearing from recently. At 9:19, Judge John Wolf stated the following as best as we can transcribe. And honestly, I'm not sure there is a difference between actual possession and possession in terms of what would be relevant to this case. So, I'm not even sure, it might be counterintuitive, okay? You can say, there are circumstances if there had been damage to the property, Mr. Byers would have had legal standing to do something. According to according to Oregon case law that we've already reviewed, there's a necessity of possession. Black's Law Dictionary online, what is actual possession? Having physical control of an object or real property. Randomly from the internet, the rule in most jurisdictions is that the landlord must deliver actual possession of the property to the tenant in addition to the legal right to possess the property. In other words, property must be ready for the tenant to move in at the beginning of the lease. I realize there's a difference between possession as it applies to adverse possession. However, okay, if I steal your red truck and you don't know what it is, do you have actual possession of it? I don't think so. Actual possession is, okay, I have actual possession of this wallet. Okay, if I rent this wallet to somebody else.
Mr. Dyke, I appreciate that you've got concerns about the issue of possession. But
So,
which of the issues you've raised today does this address?
Okay, it addresses your finding of that.
Okay.
Okay, many documents were filed in this frustrated attempt to get to the facts, which they have avoided. So you say, you criticize me for filing too many documents. A lot of those documents resulted from our frustrating discovery effort. A lot of the documents were worries about opposing. If we don't oppose, they're a mistake. Tamara did try to do that to us. She tells you in this court, frankly, Your Honor, Mr. Dyke has not appeared in this matter. Trying to say, well, there was a technicality in who signed the documents and whatever. So since they were signed on behalf of the estate, Mr. Dyke, the blanks in this room, has not appeared in this case. So that gave me this heightened concern about any little mistake that's made, they will likely try to exploit it. It's like this email stuff. They say in plain language, please direct all documents, and they try to exploit it by saying, we never consented to service by email. Where would I serve the who's it? Okay, so a lot of the documents were frustrations over errors and confusion, errors and confusion. A lot of the filings were over discovery. And then you had an opportunity at the voluntary dismissal to do something about prevailing party fees, but you didn't. I filed a motion, my first motion to deal with, I implored the court, please make findings of fact consistent with ORCP 62. And before the opposing counsel, this is another thing to put on the judicial bias. Before the opposing counsel's time to oppose my request, at the 1-8 hearing, you said, I'm going to effectively deny that by not addressing it. You didn't even give them time to oppose. Did you do that for us ever? Did you ever say, Mr. Tissot, your Hail Mary October 31st stuff is, we're not going to waste anybody's time with that. You can't buy standing to sue from somebody else. I was compelled to respond to all those Hail Mary efforts. So I was left, okay, the first time was at the voluntary dismissal. It says right there that I think it cost attorney fees. It all could have been addressed or something. Then I started on this effort. And I don't have, this isn't, I have a family to support. And so I can take it a piece at a time. I'm sorry if you wanted one simple document, but I ponder what has happened. I sit down and I write a paper on it. Okay, contempt of ORS 20.080. The core purpose of 20.080 is to encourage pre-litigation settlement. One of my documents was on that. One of mine was contempt for settlement, contempt of ORCP 17, which you know that says any attorney filing something certifies that it's true. I mean, the statements about buyers being in possession have not been true. They've even admitted that. So on and on. Okay, we made 4 conciliatory efforts. We tried to let him win by not even doing anything. Okay, and in your findings of fact, you only criticize us. You don't do the findings of fact that we asked for, that we think are pertinent. And so, you criticize our documents. A lot of those were, okay, I couldn't get all my prevailing party stuff in one document, so I did it in half a dozen documents. There was a cost document, there was a fee document, there was an attorney fee and an amended document. So, I mean, I don't know what else I can do. If the opposing party stubbornly refuses to acknowledge clear case law, what can I do? I did the best. I'm doing the best to pursue what I feel is, what I don't think. This was so artificial. The first year and a half or year was paid for probably by Stuart Title. So when Stuart Title's attorney goes and says, early on, defendants are willing to pay you $1,001, they're like, maybe this isn't affecting my pocketbook. What motivation do I have to accept that? We're not having to pay the litigation. Tell them to go to blank with their offer to settle. And then we tried to take up Tammy on her offer. You know, I mean, she had some sense there. You can see the property, I will drop the lawsuit. We said, sure. And the plaintiff said no. And so none of this is brought out in your findings of fact. You don't mention our conciliatory efforts. Okay, I mean, a lot of this is, okay, you mention our refusal of a document, but you ignore his precipitory refusal. Actually, I don't think you were there. You comment on my conduct or whatever with Mr. TISSOT. You weren't there when I went to his office to try in good faith to give him a document, and then he defaces the document and tells the secretary after she stamped it. She stamped it, you've seen it, I've submitted it 1,000,000 times. She stamped it, received this document. Oh no, tell him to go to blank. Refuse it. And then I'm like, what's a normal person going to think? I tried in good faith to deliver a document, and they refuse it to my face. And even more odious, they make a secret copy. This, unlike the TISSOT's harassing restraining order, is supported by my report of theft at the city police. I challenge TISSOT to produce any report to the police regarding their safety and me. So and then so you criticize my, I don't use the word certificate or declaration. So I have all these erratas trying to repair my documents. There's a lot of documents probably on the whole email thing. Given lack of timeliness of the statements, award attorney fees, costs, and spurs is also inappropriate. So I don't believe your criticism about the untimeliness of my documents is valid. And I don't know why you even did it. We were here a year ago and we had a meeting canceled. And I said, Your Honor, we're not ready. And you said, oh, okay, we'll reschedule it. So I only wonder, are you trying to say, I just want this off my desk, I'm going to give them an open door to move on to the appellate court? I don't know why you and Mr. TISSOT have disregarded ORCP 10. Okay, you go as far as saying plaintiff's second and third claims are fatally flawed when filed, but that isn't like based on a findings of fact and said, okay, A, B, C equals fatally flawed. It says it appears. He keeps contending that his case is valid. Second and third claims, meritless. Of course, the plaintiff shouldn't be taking the position that his second and third claims were not meritless, and were only dismissed because it appeared the claim for attorney fees would fail. For my definition of meritless is bound to fail. If you have a claim you're wanting to pursue, and it is clear, like this in this situation, he does not have standing to sue for trespass. Despite how counterintuitive it might be for him to want to sue, or how convoluted you might treat the definition of possession, his claims are meritless if they are bound to fail. And I would argue that they wouldn't be giving up on this. As upsetting as this has been, I doubt they would give up if they thought they had a valid legal claim. So, despite my appeal for findings of fact, I don't feel you made any findings of fact, even on the essential. Is it objectively reasonable? I mean, we have the original deed for this lot. Was it objectively reasonable to believe that a constitutionally protected document, people shall be secure in their papers? Isn't that reasonable? We have it a reasonable basis. We weren't ever it wasn't our preference to try to solve this ourselves. Our preference was, please, Mr. Byers, make a title claim. And they were trying to solve it locally, and there was no contract. If Mr. TISSOT would have said, here's the claim number, call Stewart Title, this is their baby, they insured this, it's their mess, you got any questions, there's a claim number. But there was no claim number, and I don't know how long into this problem, they even admitted in their documents that there's a concern Stewart Title won't make good on the claim because of tardiness. There's our original deed. I wasn't saying, Mr. Byers, go to blank. I was saying, hey, we have this dispute, here's the permission to use. So that you don't have, I'm not trying to run you off. I just feel this should be handled by the title company. And ORCP 17 does allow, if you feel that existing law should be modified. If I were doing this over, I might have to argue that I think that law of adverse possession is an anti-law, like a law of abortion. I mean, a fetus is aborted for no wrongdoing of its own. The law allows harm against an innocent party. If you're an old person in a nursing home and you happen to have a lot that you haven't visited in a while, somebody can attack you. And then all of a sudden you get a lawsuit, and you're like, I better get an attorney. So you could be in a no-win adverse possession situation, believing that your valid deed means something, and then you get stuck with a bunch of attorney fees. Is it unlawful to own property? And, if you don't happen to frequent it in 7 years in some places, bang, somebody can, try to take it from you. So this wasn't mentioned in your findings of fact, in your analysis of reasonableness. Our efforts to be conciliatory and give him the property, they're not mentioned here. Do you want to encourage other parties to to litigate without standing? I mean, that's part of this. Prevailing parties fee stuff. Plaintiff's primary goal is a quiet title to dispute property. You say that, but you don't. If that was his primary goal, why wouldn't he have stopped early on and said, oh, they're willing to give us the property. That's our primary goal. We're good with that. You said plaintiff should have dismissed the second and third claim and addressed the deficiency sooner than they became apparent. One question we have is, does the court have any power? Did the court have any power, such as requiring them to show cause? Or maybe granting us something that was reasonable on a technicality? Could granted our motion to dismiss on a technicality and let them, they didn't respond in a timely fashion. We'll let it go through because, I saw the contractor's records, I saw the assumed business name records. It very much looks like Mr. Byers doesn't live there, very much looks like it's occupied by a business and his family. You don't mention the species backdated assignment agreement, backdated to 2017. We submitted analysis of why the cases submitted by Mr. TISSOT likely cut and pasted out of the Oregon State Bar publications. Were not of significance to this. So at this point, if we were to move, if things are just unfavorable here, our position would be that we question the court's ability to understand the difference between possession as it pertains to adverse possession and actual possession. So if the party trying to adjudicate prevailing party fees is confused about possession, then of course how can they reckon the reasonableness of parties? And definitely according to Foster and the other one, we were encouraged to think because of that case, this court would be doing the same thorough analysis. So, malice is, from what I understand, willful disregard of the truth. It's one thing, Tammy, it's not malice. Okay, maybe she didn't know if somebody resided there. But she should have said, well, and she cut and pasted stuff from the Oregon State Bar publication, and she omitted the part about actual possession. She cut and pasted something on the Oregon State Bar publication. And right there, it said, it talked about necessity of possession. She selectively, so was she ignorant? I don't know, she played ignorant. But to knowingly, in his MSJ1 declaration, he said, Mr. Byers says, since 2000, the property has been in possession of myself and my family. Is he saying he's related to the Mears? If he isn't related to them, then that's an outright lie. He said in his declaration, it's been in possession, my possession or my family since 2000. I'm worried that they might not have understood adverse possession, and we're worried that lack of actual possession might have affected their adverse possession, which it can. They actually claim in their pleadings, I believe, that we had resumed possession. Well, you can't prosecute adverse possession against a party in possession. But that's a whole nother chapter that never happened. If he claims he lost possession, then his course of action would be for ejectment. From what my understanding, you have to have actual possession, but I learned that the possession required for adverse possession didn't require renting was okay. We acknowledged that. We tried to be people of truth. I didn't act like an idiot. You make it sound like I was unreasonable in adverse possession. I opposed their MSJ1 for adverse possession because of all the extra content that went beyond Claim 1. Just like the lawsuit, there's all this stuff that goes beyond. You say his primary goal was quiet title. If that was his primary goal, why did he pollute his lawsuit with all this crazy stuff? If his primary goal was adverse possession, why is MSJ for adverse possession? You even said, if their papers say that unicorns are real creatures, then, well, that's okay. I mean, to a self-represented person, stuffing all this misleading, confusing stuff in there, it's like, what kind of consequences is that going to have? You did clarify. This is only on the simplicity of quiet title. You did that. That was like, okay, it's relieving. We don't have to worry about whatever crazy traction they're trying to gain here for claim 2 and 3. So this is on the topic of cost and disbursements, because you say, well, there's 3